Letters of administration is the process of administering an estate when someone dies without a will. So the first step would be for an administrator to be appointed, and the administrator would be in charge of the estate and essentially would step into a role that an executor would have done. According to the Succession Act, only a select group of people are eligible to be administrators, and there's an order of priority. You will usually see spouses, then children, parents, siblings being administrators. Unfortunately, there can be argument between that group of people about who is the most appropriate administrator. And this is one of the downfalls of dying without a will, because before we've even got into administrating the estate, there can be an argument between who should be the administrator, and that will require either extensive mediation, everyone lawyering up, and maybe even court intervention just to decide who's going to administer your estate. Once an administrator has been identified and appointed, the administrator then needs to identify the estate and quantify the estate, writing to all of the banks of the deceased, share registries, getting market appraisals, and creating an inventory of assets for the estate and valuing it. They then make an application to the Supreme Court and set out the estate assets and liabilities. The administrator also needs to tell the Supreme Court who would be eligible to receive the estate under the Succession Act and in accordance with the rules of intestacy. So the administrator needs to identify who's eligible to get the estate and provide evidence to the court of those people. So that might be simple if we're in that scenario. The death certificate of the deceased would usually list the spouse or marriages and the children of the deceased. And then we would provide the birth certificate of the children, marriage certificate of the spouse to prove that they are the eligible person. However, it can become significantly more complicated if we're going down the line of succession or intestacy. If eligible people have died, we need to apply to births, deaths and marriages to get their death certificate to prove that they're dead, find out who the children of the deceased beneficiary would have been, and it can actually take a really long time to track down who the eligible people of an estate are when you die without a will. Once we've identified who the eligible people are and the application has successfully went through the Supreme Court, the Supreme Court grants letters of administration, and that grant sets out the assets of the estate and who's eligible to receive the estate, and the administrator can then go about the process of realising the estate and administering it, and then dividing the estate to the eligible beneficiaries under the Succession Act. Letters of administration bears a lot of similarities to applying for a grant of probate, but there's just a lot more work to be done. You have to prove who the right administrator is, and you also have to prove who the eligible persons are entitled to receive the estate under the rules of intestacy. There's a lot more room for disputes, there's a lot more delay, there's a lot more work that has to be done, and it's generally just a lot more stressful. So I do encourage you to make a will. Wills are not perfect. No legal process is perfect, but having a will is a lot simpler, leaves less room for dispute, and I highly encourage you to make a will and not just leave it to this letters of administration process. As a lawyer, I really cringe when people die without wills because there's just so much more work that has to be done for an estate. And I find that families are often just really over it at the end of it and actually really are annoyed that you didn't just make a will. Making a will doesn't have to be really hard. It doesn't need to be complicated. If you just want a simple will, that's better than having no will. Please consider just making a simple will rather than making no will at all. If you do just want a simple will, you don't even need to go and see a solicitor. You can use a product like Wills No Frills that helps you draft a well-worded, simple, legally binding will from your own home. The Wills No Frills wills are better than you just trying to do it yourself because they are drafted by a solicitor and checked by one of our solicitors before they're sent out to you. So you have the peace of mind that knowing that solicitors checked it, it is a good, well-worded will, it meets all the legal requirements. And it's a great option if you are sitting on the fence and may not necessarily want to come and see a solicitor or can't afford it or don't have time, but you know that you probably do need to make a will.